Thank you very much, and good evening to everyone. Thank you for inviting me to this very important panel discussion. And I saw the eminent speakers presenting on the very important areas and concerns about the matters at hand with the Express Pearl disaster that occurred. And so I'm very grateful for the organizers to have invited me to make my presentation on the measures taken to ensure the safety of oceans. So if I may go straight away up down my presentation, we know that Express Pearl was not a natural disaster. It was a human error, of course, but we cannot blame the humans that were involved in this particular disaster, because especially the crew, they were on board serving the vessel as employees. But, you know, by law, whenever you put something dangerous to the sea, those who put or keep such a disasters or polluted elements are strictly liable in law. So that's the legal concept to start with. And as we see that I very basically use my presentation today, I would like to note that the background is black because we are facing a very black situation. I have been using very colorful presentations whenever I make presentations, but with regard to this Express Pearl incident, we know that we are at black, we are at dark, right? So it was a Black Tuesday of Sri Lankan coastal water. Firstly, May 20th was the chemical fume emissions erupted on the Singapore flagged MV Express Pearl container ship as it anchored around 9 nautical miles northwest of the port of Colombo in Sri Lankan national waters. As Professor Ajit mentioned, that this is a ship that shouldn't have come to our waters, because I've been telling from day one, you know, that it should have gone to a place of refuge. I will just correct Professor Ajit on that, because, you know, it came from Jebel Ali to Qatar, and then to India, and then to Sri Lanka. But if the Qatar port and the Indian port still refused, they could have gone to a place of refuge rather than a port of refuge, because that's the normal concept in the international law and international maritime legal aspects. Right now, many research papers have been developed in the area of place of refuge, and still this particular ship could have been taken to a place of refuge and then diffuse whatever the dangers that were there in the ship and take it to Sri Lanka thereafter, right? So that's why I say that it was a human error rather than of any other cause that may have occurred to the ship. It was really a human error, but of course we cannot blame now because things have happened by now. But Tuesday, the May 25th was the Black Day in Sri Lanka. Sri Lankan maritime history. Unknown number of containers, some of which carrying dangerous chemicals and plastic pallets, reportedly fell overboard as an intense fire broke out and explosions occurred. Then what happened on the June 2nd? An effort to tow the vessel to a deeper water refuge failed and resulted in partial sinking of the vessel. Even before this particular step that was taken at the presidential secretariat, I told to many experts, don't do this. This is going to end up in a disaster if you take it, if you tow it. But who pursued that particular decision to be taken at the presidential secretariat? I mean, it wouldn't have sunk if we really observed what was going on. And I'm very confident that I spoke with many experts in the shipping industry, especially the captains and marine engineers. Water wouldn't have penetrated into the engine room if not a valve has been removed from the engine room. Somebody has removed this valve. right? That was the reason. I mean, I'm talking with expert knowledge that I have extracted from marine engineers, especially in a vessel like this nature, right? So somebody may have taken out the valve, because if this ship is to be salved, it would have cost millions of dollars at that point. There is no use of the ship thereafter. So somebody who knew the after effects may have taken such a decision to take out the valve of the engine room. This is very sad situation for Sri Lanka. We are talking about our country. We are talking about our maritime waters. And it became a useless wreck as what it remains now. Finally, we could have at that moment taken certain steps to minimize the loss and damage. That is what we could have done. Then on June 17th, the entire vessel had settled on the seabed at a depth of about 21 meters with only castle and some of its cranes partially visible. We all know this. But what happened next? A large black smoke, potential spill of 15 products classified as dangerous goods, including 25 metric tons of nitric acid spill, large quantities of plastic pallets, cargo, and other debris from the vessel washing ashore. A long but limited oil slick continuously leaking from the ship, raising concerns over a major sudden spill of the 348 tons of bunker fuel aboard the ship. We know these facts. These are now public. We can't hide them. A cleanup measure and preventing further damage, designing and implementing an environmental assessment, preventing, mitigating, and responding to the risks from the incident, strengthening national capacities to deal with future maritime disasters, were taken up by MIPA, because that's the national agency responsible for these types of environmental issues. Then examining the legal mechanism to combat marine pollution and obtaining compensation for the loss and damage. Then only we are talking about the legal elements. Until then, people have been sleeping on our law, because our law was not developed to the extent that we should have responded in these kinds of situations. I have been very outspoken, and I have been telling from day one that, you know, we will face a legal debacle here, and our law is not developed or reformed to that extent. Some people really blame me at that moment, but now even the more eminent lawyers in this country have told to my face that I was right. Now they have realized, but it was too late. Because forgetting about the criminal aspects and concentrating on the law on civil liability, we know that the basis of liability is the strict liability placed upon the keeper of such pollution or pollutant substances. This is the international law on which the liability and compensation regimes were developed. They derive from the English common law case of Rylance versus Fletcher, where if a keeper of some property affects damage to another, the keeper himself is strictly liable without any excuse. So negligence is not a basis of liability here. It is the strict liability. And this was taken to the conventions, and the conventions were developed later on by the International Maritime Organization based on the Rylance versus Fletcher judgment, including the hazardous and noxious substances, the OPRC 2006, and the bunker oil conventions that are more relevant to the incident of Express Pearl. Then if you look at the MIPA, the Marine Pollution Prevention Act number 35 of 2008, it provides in section 34.1, because that is the only legislation that we do have in order to obtain civil liability and compensation in a case like this. states specifically that where any act referred to in section 24 or results in pollution, damage of the territorial waters of Sri Lanka, the owner or the operator of the ship. Now, that is what I had been mentioning as the keeper, who is strictly liable as per the Rylands versus Fletcher, right? The owner or the operator of the ship shall be liable for, what are they? Any damage caused by the discharge, escape, or dumping of any oil, harmful substances, or the pollutant into the territorial waters of Sri Lanka. B, the costs of any measures taken for the purpose of preventing, reducing, and removing any damage caused by the discharge and further damage. So these are the things that we have to concentrate in getting the compensation due. Then, for what can we get? For what things can we get these compensation? The interests that cover relate to the territorial waters of Sri Lanka, including marine, coastal, port, and estuarine activities, including fisheries activities, the promotion of tourism and preservation of development of tourist attractions in territorial waters of Sri Lanka, including beaches and coral reefs, the health of coastal population and their well-being, the protection and conservation of living marine resources and wildlife. This is a very huge scope. This is a very huge scope. If you look at it, it can go into other branches. Like, for example, take tourism, for example. It is not only the beaches that are damaged or polluted. Also, that when the tourists are not coming, there are claims from the hotels. The hotels have taken loans to build them. The hotels, the entire hotel industry collapsed because of this. You see, it's just the pollution of the marine, of the coast, but you see the extent to which that the damage compensation goes. And imagine a person who is like making sculptures in a far place like Kandy. He can also get, because his businesses are directly, if his businesses are directly involved in the selling of such sculptures and other things in the coastal areas. So not only the coastal community, but also the non-coastal community can obtain compensation in these kinds of situations. So the interpretation, the definition, and the scope of the losses, damages, and compensation run into a huge area. Now, the next point is who shall pay? Who shall pay? The polluter under the polluter pays principle. That is including the registered or unregistered ship owner. Ship owner in possession, like for example, the person who is not the registered owner, but a person who is in possession like a bareboat charterer. Then operator of the ship, charter in voyage, time or demise. So all these plethora of entities and persons are covered within the responsible parties, the liable parties, under the polluter pays principles doctrine, or rather the principle, right? However, liability does not channel to protection and indemnity in our law, has no direct action provisions available in the law of Sri Lanka. This is something that I have been telling, to include the direct actions, and in the recent amendments that I have been attending together with MIPA also, I pointed out, we have to include these direct provisions, because if the ship owner goes missing, nowadays the shipping industry is that they register one single domain or a company for a ship. So if the ship is lost, that shipping company has lost its entire asset. There's nothing that they can pay. So that is why we had to bring in the P&I Club as the responsible entity that has given insurance. And in a ship, there are various number of insurances. It's not only one insurance like in our own land vehicle. There are multiple insurances, including the wreck removal at present. The wreck removal insurance policy may run up to billions. So there we still can bring in some compensation packages if we had the provisions of putting direct actions against the P&I. So under the pollution cover, thus settling ship owner for loss to the ship hull and machinery, which the express lines has already recovered. It's hull and machinery loss. It is only we who have lost and we who have not yet recovered. Then absence of limitation fund and provisions for constituting fund in Sri Lankan jurisdiction has prevented the country from obtaining security though it had the golden opportunity to arrest and detain. That was missed at the time of the incident. I'm telling you, at the time of the incident, we could have, because then the ship owner or the PNI has to come to our jurisdiction, constitute the fund, whatever the damage that we are claiming, they have to constitute the fund legally. But now what they are trying to do is to constitute the fund in UK and keep the fund available in UK. And we have to go and claim from UK courts. And that falls into the problem of forum non-convenience as in the law, because UK is not a forum convenience for us. It should have been the Sri Lankan jurisdiction where our court could determine on the quantum of damage and compensation. The claim, while final calculations are still being made, an interim claim submitted for 31.8 million USD, but out of which only we have secured 3.6 million to date. But I heard some information that they are now trying to settle further 2.4 million or so. But at the moment, we have received only 3.6 million. And it is less than even 10% of the interim claim that was asked for. Then that is out of the 10 types of items. When I looked at the claims manual, the claims form, I found that they have cut down most of our claims on the basis that we have failed to give particular receipts. This is crazy, right? This is crazy. If you look at the situation reports of Exxon Valdez or situation report of the other great maritime disasters, you would see that they have not relied upon these kinds of things, these kinds of, some vague claims like we have presented in Sri Lanka. We have to get those reports, study them, and see how they have done. The developed maritime nations like UK or US, how they have done. So, what we have not followed with the situations report and to get the thing. I'll come back to the interim claim later, because I have been, when I heard about this interim claim, I told not to go for the interim claim for one reason, which I will explain later. These items included whatever we have now received as interim claim for 3.6 million cover salvage personnel, SLAAS operations, SLN and Coast Guard operations, SLPA costs, MIPA preparedness, cleaning expenses, transport, waste, storage, disposal costs, equipment hiring and deployment costs, admin costs, inspection and sampling costs, and fisheries claim. Cleanup and fisheries claims settled at a higher number as 1.38 million and 1 million respectively. However, leaving major fisheries claims unsettled, with fishing community recently obtained leave to proceed in their fundamental rights case in the Supreme Court. Moving back to the interim claim and obtaining far less compensation has led to the accepting of PNI position. Now what we have done, I told at that moment, don't go for this interim claim at that moment. Because why? Because we are accepting the PNI position, and that what has happened now by cutting down our claims one by one. I have seen that report. They have cut down our claims one by one, saying that we need the receipts, we need the costs. I mean, very basically, for transport cost, how can we give receipts like that? For example, I'm telling, right? But they have cut down all these things and arrived at that 3.6 million USD. And rather, now what has happened? We can't go for a case Because once you accept an interim claim, we are stopped by law. We are stopped by law. We cannot go for a claim unless it's on arbitration, if the parties agree. Deficiencies in the exercise. The law itself has terminological, application, and procedural deficiencies that have been long overdue amidst various reminders to reform. But however, after the incident now, we are looking at reforming the Marine Pollution Prevention Act and try to make it more stronger legislation that could meet the legal preparedness for the future. Technical capabilities of operational teams are insufficient and lacks hands-on experience in like scenarios, further worsened by lack of appropriate equipment, apparatus, and the pre-incident, when the incident occurred situ, and the post-incident circumstance. So I'm not blaming the authorities we are having in Sri Lanka because of the fact that this kind of a situation is not natural for us. It won't happen every time in Sri Lanka. But we did have the opportunity to get the experts from places where they have experienced this. That's why I said that we could have looked at the situation reports of Exxon Valdez and other major disasters, and then get some expert opinion on how to go forward, how to move forward, rather than taking our own decision as to, we present an interim claim and then we go to the P&I club, whatever. But if you look at the situation reports of those incidents, you will see that those countries have been very strict, very stringent in punishing, in a civil way, punishing the perpetrator or the polluter. Law enforcement and state legal departments act in stale pace. I can say this very openly. Without much knowledge on the subject, thus obtaining advices of inexperienced international law firms that should otherwise have competencies in pollution damage assessment and ways of obtaining compensation. So I don't want to mention the names or the names of those countries, but before we select a law firm, we have to find what are their experience, the hands-on experience in these kinds of situations. Not just the pollution prevention, but in a disaster of this nature, how they have acted. We need to get foreign expertise on those areas without prejudice to our experts locally handling in different expert panels. I'm not accusing any of them, right? Because we have the available resources, human resources, but we also do need some foreign experts who have had hands-on experience in situations like this. So they need to be represented also. Their views are very important for us. Then what lessons have we learned and the ultimate outcome? The incident, sine qua non to discharge or escape of harmful substances. This is connected. One is connected to the other. Without one, the other cannot exist. This is what we call in Latin sine qua non. So that the causation is linked to act or omission, to the resultant damage or loss that we are still experiencing with the removal of debris, removal of containers, removal of the wreck finally, all these things. And the application of precautionary principle to prevent or minimize damage caused or to be caused by pollution damage or threat of pollution damage. Post-incident impacts, disaster management techniques, and quantifying damage or loss to be realistically assessed so as to obtain adequate compensation. We are talking about adequate compensation. We can't have, overrunning compensation. Like, I know we have very good economists who can do these proper calculations, but at international level, it's the adequate compensation, the words that are used to in a pollution incident, because in order to balance the shipping industry with the damages that cause. The shipping industry must maintain that balance, and it is very important for a state to only ask for the adequate compensation for pollution damage, preventive measures, and further loss from preventive measures. Adjustment of management policies, consideration of economic losses, as Professor said, on the economic aspects, direct, indirect, physical, economic loss, all these things have to be calculated. Futuristic harm. And like Professor Dialvis also mentioned about how many years are we going to suffer because of this? Maybe 500 years, we do not know. And vague legal intervention in designing post-incident contractual arrangements, especially with regard to wreck removal. We have no hand in that. The wreck removal agreement has been signed between the vessel owner, the PNI, and the salvo, right? So the cooperation agreement have to involve Sri Lanka. I don't know who has given these legal advices, and including wreck debris removal through state-defined approaches. They have to be very specifically addressed in the removal of wreck and debris. These are the next post-incident things that are going to affect the Sri Lankan waters. And I think my eminent speakers who spoke before me also mentioned about these things, that we are still not done with this incident. It's still going on. So failure to ensure safety of oceans, that's the topic that was given to me. International obligation of the state to ensure safety of navigation and the duty to safeguard sea under UNCLOS being primitive and results in infringement in a collective and cooperative manner involving flag state control. Because the flag state is Singapore in this matter, and Sri Lanka is the affected state. So we need to have proper cooperative mechanisms involved. It's not really the ship owner, it's not really the PNI. The flag state itself has to come into the picture. Leaving legislative and jurisdictional lacunas in failing to comprehensively overcome ill-fated measures that underestimate sovereignty of state. Because if we fail to take proper measures, we are disputing the sovereignty of this land. Because the sovereignty remains with people, not with an institution alone in this country. The sovereignty is with the people. If a public servant takes a wrong decision here, it affects the sovereignty of the people, because to state which the government authorities and public servants become responsible to the general public and the people of the state as custodians of public properties. Recently, in a very important judgment in the Supreme Court, His Lordship mentioned that the public servants have to take the proper decisions because they are custodians for the general public. In the elephant case, the active and stringent manner in which the recent incidents of MV Ever Giver in the Suez Canal, MV Vakashio in Mauritius, MT Navios Amaryllis in Maldives were handled, provide good examples of non-cowardly and non-corruptious approaches of coastal state, thus leaving a huge question before us: have we done our part? Because if you look at those examples, those countries never gave up. They were very strict. Even the Vakashio case, the captain and the chief officer are still in their custody, and the chief officer is a Sri Lankan. Now for over 2 years, for a pollution damage, thus they complain for breach of innocent passage. And we have to be sad that we do not have the provisions of breach of innocent passage in our law. We are talking much about, member of the UNCLOS, the Law of the Sea Convention, because the very simple thing, the breach of innocent passage, is not in our law. This is what I have been telling in the media, even those days, that this particular ship, Express Pearl, breached, in my opinion, breached the right of innocent passage by reporting to our coastal waters rather than staying in a place of refuge. But how to sue them? We don't have the legal provisions for breach of innocent passage. But Mauritius had, that is why they sued Wakashio under breach of innocent passage. Thank you very much, but we are still at dark.
Thank you, Dr. Gunasekera. I think that paints a pretty black picture for the future.